Hello, everybody. It's 9:03 here in New York. Today, I want to share something really interesting with you. And we're in day 397 of our quarantine. No, we're not on 397, but it reminds me of the movie Avatar, where Jake, the main character, is sitting in front of this computer doing video blogs each and every day to record exactly what's going on. All right, so today's topic is going to be what can happen. What bad things can happen if you say, I don't know, during your pretrial deposition? You want to know the answer? Stick around as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so we're here in quarantine. Now I have a few minutes to share with you some great information. Here's the scenario. You brought a lawsuit against a careless doctor claiming that the doctor was careless and caused you harm and injury. And you know what happened now? Now, you've decided, hey, I think the doctor was careless. I have a medical expert who has determined that, yes, he was careless. Yes, he violated the basic standards of medical care, and that his carelessness was a cause of your injury. Great. So now during the course of your lawsuit, you will have an opportunity to be questioned by the attorney who represents the doctor whom you have sued. That's known as a deposition. It's pretrial testimony. And you know what else? That takes place in our office, typically in our conference room when we're not quarantined and locked down. And now, what happens then? The attorney who represents the doctor will then have an opportunity to come and question you. Now, they're going to ask you lots and lots of questions. Hey, Dan, nice to see you. They're going to ask you questions about what happened to you. They're going to ask you questions about what injuries you have, what disabilities you have, what problems you have now compared to what you have before. So now, during the course of questioning, there will be times where you will not remember exactly what happened. There will be times that you will not remember exactly what complaints you made to the doctor, or what the doctor did, or what the doctor said. There will be dates that you will not have an exact memory of. And so what are you going to say? You're going to say, typically, I don't remember. Now, is there any downside to saying I don't remember? The answer is yes. And I'll tell you what the downside is. Hi, Bill, nice to see you. The downside is, if you say over and over and over again, I don't remember, I don't remember, I don't remember. Now, the attorney is going to have a significant issue. Why? Because there may be a credibility problem there. Unless you have amnesia, where you certainly don't remember anything that's going on. Now it becomes questionable about why. Why is it that you don't remember something that happened a year or 2 or 3 ago? Is it something that happened because the passage of time has elapsed and now you have forgotten many of those things? Or is it something that you do remember but just don't want to tell the attorney about? It could be a number of different factors. So the reality is that when you are being questioned at a pretrial question and answer session known as a deposition, the whole point is the attorney wants to get information to learn in your own words exactly what happened. Hi, Elise, nice to see you. They want to know from you exactly what happened. They will have the doctor's version. They'll know what the doctor has said by talking to their client, right? But they don't know yet what happened from your viewpoint. And now they're going to ask you critical questions about what you remember happening. Now, I have to tell you something else. Even though you are giving this pretrial testimony, you might think, hey, I'm just going to the attorney's office. I don't have to get dressed up. I don't have to, answer as if I'm at trial. Well, that's wrong. That's incorrect. Because the testimony that you give, the answers to the questions that you are given, guess what? Those questions and those answers are recorded by a court stenographer known as a court stenographer or a court reporter. Hey, Cindy, nice to see you. So we're talking today about what could happen if you say, I don't know, during the course of a pretrial deposition. So now you're at the deposition, you're being asked questions, and there's no judge there. I should have told you this earlier. There's no judge sitting in the room with you. There's no jury sitting in the room with you. So instead, it's your attorney, the defense lawyer, and a court stenographer there to record all of the questions being asked and all of your answers. Now, while you are being questioned, you should know something else. The answers that you give carry the same exact weight as if you are testifying at the time of trial. Now, so many people turn around and say, wait a second, I'm sitting in my attorney's office. What do you mean it carries the same exact weight? The reason is that your answers is sworn testimony. And now, if your case goes all the way to trial, let's say a year later, your case finally comes up for trial, well, guess what? You know what happens? That prior testimony can now be used against you. And that's exactly what the attorney, the opposing attorney, is going to use it for. They're going to ask you questions on cross-examination after your attorney is done questioning you. And now the answers that you give should be consistent with everything you have said in response to his questioning during your deposition. And if it is not, you know what the defense attorney is going to do? He's going to pull out that booklet, that transcript of the questions you were asked and the answers that you gave, and now use it to contradict your testimony. Hang on one second. So now, let's get back to the title of this video. What happens, what bad things can happen if you turn around and continue to say, I don't know. You just want to get out of there, you've been there for hours, and finally you're so fed up that the defense attorney asks you one question after the next, and you know the answers, but you just don't want to give it to him. You don't want to go ahead and enlighten him. So what do? You get fed up and you say, I don't know. You're just clearly fed up. Well, I'll tell you what should happen at that point. Your attorney should recognize your frustration. And now they should call for a break. Your attorney should call for a break, or you should. And now go out in the hallway, take a breather, walk around the neighborhood, walk around the office, so that you can get your mind clear again. Hey, John, nice to see you. So that you can clear your mind and now reduce that frustration level. And why is that important? Because now when you come back in, you're not going to have that same level of frustration. DJ, nice to see you. Instead, you'll be a bit more relaxed. And now, maybe you do remember. And now maybe you want to correct some of those things that you continue to repeat, saying, hey, I don't remember. Now, many times it is important for you to try and remember. And, hey, Dave, nice to see you. You can actually go ahead and tell the attorney, listen, I remembered this 2 years ago, but 2 years have passed by. So many things have happened. Yes, we're still alive, Dave. So many things have happened since then. I just don't remember the exact details. And I'll have to tell you something. That's perfectly acceptable because nobody is expected to remember all the specific details that happened to you. And something else. If, in fact, great to see you too. It's so nice to see you on this live video. If, in fact, a witness actually remembered every single detail, every single date, every single comment, Ali, nice to see you, that would be highly suspicious. You want to know why? It's because it's extremely, let me say it this way. Human nature is such that with the passage of time, we forget certain details. And now, if you were to remember every single detail of every single event, as if you had a video camera and audio capturing every aspect of everything involving this care and treatment by this doctor, the attorney would be highly suspicious. And because of that, they have to wonder, okay, you remember every single detail? How is that possible? It's not possible. It's highly unusual. So instead, it's perfectly acceptable for you to say once in a while, listen, I don't remember. I did remember at one point, but I'm not sure and I don't want to guess. And another thing you should know, your attorney should be telling you at the very beginning before you even start, listen, as part of the preparation, if you are asked a question to which you don't know the answer, you are not to guess. Why? Because when you guess, you could be right, but then again, you could be wrong. And the last thing you want to do is give an answer that could possibly be wrong. Why? Because now when you get to trial a year later, now you finally remember because you reviewed some records, you reviewed a document, and now it refreshes your memory. And now you're going to give an answer that's dramatically different than what you gave during your pretrial testimony. So if it turns out during your pretrial questioning, you are asked the question to which you don't know the answer, it's okay to say, listen, I don't remember. And now, maybe a year down the road at trial, you're shown a document and you say, wait a second, now I remember. The answer is X, Y, and Z. But if you turn around and give the wrong answer, well, now you will have contradicted yourself. So can it be a bad thing if you say, I don't remember? Hang on, Dave. Can it be a bad thing? The answer is yes, depending upon why you are continuing to say, I don't remember. All right, Dave, let's see what you have to say. When you work with a witness, how do you prepare them what to remember and what's too detailed to recall? Just go by the deposition? Okay, great question. So really the question is, how do you prepare a witness before they go ahead and answer these questions by the opposing attorney? Now, it's important to remember that one of the key things we tell these witnesses, you have to be honest. And if you remember, tell the attorney that you remember the answer. If you don't, you have to tell the attorney that you don't remember. The last thing you ever want to happen is to have the witness give an answer to which they intentionally misstate something. We call that a lie, to which, or another word is called an untruth. And that's more of a politically correct word, but the reality is you never want a witness to lie, and you have to tell the witness, listen, you are to tell the truth. That's why you're here. Because in almost every instance, if you tell even a little white lie, that's going to come back to bite you on the butt. So how do you prepare them what to remember? You never want to show them any documents during the prep session. Why? Because anything I show them, now the defense attorney can ask, hey, did Mr. Oginski show you any documents? Oh, yes, he showed me these 2 documents. Great. Anything that I showed him that the witness now acknowledges, he can then look at. And now he can ask him questions about it. So if it's notes, if it's something in a textbook, if it's something else, hey, Josh, nice to see you. All of those questions can now be asked of the witness. And if I did, in fact, show him something, now the attorney is entitled to look at it. And we never really want to be put in that situation. So I might ask my client, hey, Mrs. Jones, what do you remember happening in the doctor's office on May 1st? Well, I remember some of these things. Now, I will have those medical records, and I might be reviewing them, and I might say, hey, Mrs. Jones, did you say to the doctor anything about this particular complaint? What did the doctor say in response to that? Okay, so I'm not putting any words in the witness's mouth, but I might show them something to refresh their memory, and once they have that, now that information that I showed them, a document, a picture, or something else, now the opposing attorney can use that or learn about it and then ask questions about that. So, getting back to the title of this video, is it a bad thing? Can it be a bad thing to say, I don't know, I don't know, I don't know, leave me alone, I don't know? The answer is it might. If it turns out it's because of frustration, the witness doesn't want to be there anymore, they're tired, they're frustrated, the answer is, yes, it could hurt them. Take a break, calm down, relax, come back 5 or 10 minutes later, and now you might just remember certain things. Now, one last thing I do want to mention. If the defense lawyer shows you certain documents and says, Mrs. Jones, I'm showing you a portion of the doctor's medical record, it indicates that you complained of the following things. Does that refresh your memory? And you know what? In some instances, it does. In some cases, the witness will say, oh, yes, I do remember now. In that instance, now the attorney will go ahead and follow up with those questions along those lines. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these pretrial question and answer sessions known as a deposition, in these civil lawsuits involving medical malpractice, especially here in New York. You know, I recognize you likely have questions or concerns while you're sitting in lockdown, while you're quarantined, and now it's 9:15, 9:17 here in the middle of the night, it's in the evening, and you happen to go through Facebook and you see this video talking about, is it a bad thing to talk about or to say, I don't know, during a deposition? Well, hopefully this has given you a little bit of an insight into what you can and can't do during these depositions. You know, if your matter happened here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for tonight, everybody. I hope you have a wonderful day, wonderful evening. Stay safe, everyone. Take care. Bye-bye.